lots of discussions, if we want to call them training, on emails. I know Jeff has talked about that quite a bit. I kind of agree with Jeff. There's just too many emails that are just uncalled for. They have become, people don't pick up the phone anymore. So we've tried to encourage people to limit their use of emails. I think that's the biggest takeaway. And what I've encouraged in the civil engineering department here is really an overall strategy of really laying out for each project what your documentation needs to be, and really spending the time to make sure the documentation is adequate. None of us want to be in lawsuits. I think it's pretty rare that most people get sued, but when you do get sued, the outcomes are terrible if your documentation is not in order. And so I think we've just paying a whole lot more attention to all of that as a result of those experiences, for my case, about 2.5 years or so ago. So I hope that answers that question, Bob.
This came in, I think, during your presentation, Matt. It says, as client, is it advisable to ask formwork manufacturers engineering to design form pressure for full liquid head?
If I understand the question properly, so they're asking if you're permitted to review the calculations from the formwork manufacturer?
Yeah, I'm not sure. It just says, as the client, is it advisable to ask formwork manufacturers to design full form pressure for full liquid head? It kind of depends on.
Oh, okay. I misunderstood. So it's not advisable to design formwork for full liquid head. What that would entail would be completely inefficient formwork systems. Right now you're probably, it varies, but a lot of form systems are designed for 8 to 12 feet of liquid head. So when you have a tall wall placement, it's not efficient to design the entire height of the placement for full liquid head. What makes sense, and what I tried to get across in my talk, was that a combination of measurement of the actual form pressures, and then timing and proper planning and timing of the lifts is the methodology that I would suggest.
All right, thank you. Next, was there no in-service inspection of the bridge prior to adding additional weight? I think you're talking about 35W bridge, and the answer is no, which is remarkable. But no, there wasn't. And that's, in my mind, that's part of the issue. Next question, can you speak to what you're seeing with the use of Microsoft Teams, Slack, etc. for communication? I assume it's no different than email as it relates to discoverability and usage strategy. Yes, to the extent that it's recorded. I can tell you that one of the hot issues for my clients, my A&E clients over the last year, has been, how do we handle construction administration site visits, particularly with individuals who aren't comfortable visiting the site. Now, in some ways that raises an employment issue, in that, can you force people with I've learned a new term this last year, comorbid conditions. But if you have people who are scared to death of going out with COVID-19, can you force them to do field visits? There have been a lot of virtual field visits, and I'd like to ask the consulting engineers on the call, or on the program, like Bill and Randy and Matt, what are you seeing with site visits in your practice?
Randy, you want to go first?
Yeah, we have still been going to the site, Jeff. We exercise the guidelines by CDC and make sure that we're wearing masks and that we don't group together and do what we need to do. And if we end up having to have a conference with the client, we do it in a room, we're 6 foot spread and so forth. So we're to the extent that we need to be there and observe things, that's what we do. Same with us.
Yeah, we're doing site visits as well, but some of our clients definitely have their own protocols. Of course, being in New Orleans, we do a lot of oil and gas work, and yes, oil and gas work is still going on. But companies like Shell, before you can go offshore, which we have to go offshore quite a bit, they actually quarantine our staff for a period of days at a hotel. They have an entire hotel rented out, and they quarantine the staff prior to going offshore. But site visits are still they're still going on. We haven't done anything virtually regarding site visits, at least not here.
Well, I do have some clients that are doing virtual site visits, and that raises the question, you know, you're relying on somebody in the field walking around then with an iPad or a camera or a phone or something. But I know some of those are happening. Another question, the aquarium
Jeff,
public. Yeah.
Jeff, when you were talking the question about Teams earlier, I mean, related questions are about the use of Facebook, Facebook Messenger, iPhones. How much of that is discoverable if you're using that on projects where it's potentially discoverable?
It's all going to be discoverable if it's recorded or recordable. The other thing I'm seeing is discovery requests for text messages.
Yeah.
Yeah.
I've got text messages that I've got as key exhibits in a case involving a concrete supplier. Text messages are also discoverable.
Now,
I think it's a misconception that texts are somehow private.
Nope.
Now, also photos, if you're taking photos with your iPhone, in my case, that became under scrutiny because the photos have, of course, coordinated locations on the images. So it became an argument about where those pictures were being taken. And so the type phone has different proximity requirements. And so the phones themselves became discoverable. And as a result of that, at least internally, we have discouraged people from using their personal phones to take pictures of jobs and to use going back to just digital photos and not using iPhones.
Okay. Bob had a couple questions. Risser, was it a public or private? Was it low? Yes. Low bid was required, and that's one of the problems. And the funny thing is, I know this contractor owner really well. I won't mention the name. And we get along great, and I see him at cocktail hours and stuff, and he walks up to me and says, you know, I still don't understand what we did wrong on that case. So I don't think he's done any more aquariums, though. Here's a question for Bill. So the problem was documentation and communication, but was there any suggestion that someone stole concrete or deliberately misrecorded volumes of concrete? Did anyone really misbehave in the field? Was there any evidence of that or examination of it?
Dave, that's such a great question. It kind of gets to what I alluded to earlier, that the site was built on marsh and basically reclaimed swamp. The concrete that was being utilized and demolished was actually stacked up more than 60 feet tall. So you can imagine the weight of all of that concrete sitting out in the marsh.
Whoop, Bill, you froze up.
When you went and looked at the site, let's try stopping video. How's that?
All right, go ahead. I can hear you now.
How's that? Okay.
Probably need
So,
backup.
okay, so the concrete on the site was stacked up over 60 feet in height. And if you can think about all of that weight, 60 foot of concrete stacked up in debris on that old marshland, you can kind of start thinking about what's going to happen after that was gone. We actually dug pits and found concrete. I don't think there's anything wrong. There was lots of disputes about where that concrete came from. I don't think that anyone was cited for stealing concrete, but it was still in dispute. And it was interesting that as a civil engineer, kind of a side story, they would not allow me to talk about soil settlement and what those soils would do with all of that concrete on it. They deemed that outside of my area of expertise. That became interesting to geotechnics, and we just know the soils here are just terrible. So I wouldn't say anybody did anything wrong. It was just a whole bunch of issues, and that there was really no good documentation of that concrete going back and forth from contractor A and contractor B. I think that would have solved the whole problems.
And Bill, you were cutting in and out. So just so you know, that was a question from David Lang. So you guys might want to convene in the bar after this conversation and talk about that more. But having listened to Bill's conversation and presentation a couple of times before this, we've done this together a couple of times. Project documentation. I can't tell you how many times cases come down to documentation and particularly documentation of critical issues. It's of critical importance. And I think part of what Bill said was there, in some cases, there wasn't really good documentation about volumes and deliveries and so on. There's another question about, is the training something that could be turned into something ACI can offer for employees? Probably yes. I'm not sure, Bob, if you're talking about the training about emails or training. Maybe we can follow up on that afterwards, but I can tell you that ACI has no problem offering educational programs. So that might be one on email, text messages, and electronic communications might be a good short training video that we could put together. It's a good point. Next question, are there any guidance documents for spreadsheet control? That's a really interesting question, and I'm not sure that there are. You'd have to go through some case law, and I have to confess that in my career, this is the first time I've heard of a spreadsheet not getting admitted. I've admitted all kinds of spreadsheets in all kinds of cases, and I have to laugh because when I ask an engineer a question, I get a spreadsheet. And my record was a spreadsheet that I literally would have to stretch across the wall of the back of the courtroom to get everything on. It involved 520 driveways that had to be replaced due to pop-outs, and we had a spreadsheet with all the issues of the 520 driveways, and I couldn't get it. I gave my client afterwards, we celebrated the outcome of the case, and I gave him all these spreadsheets with a magnifying glass so he could read them. But yeah, spreadsheets, I have not had this case where I couldn't get a spreadsheet admitted. And I do question it because if there's questions about the spreadsheet, that should be subject to cross-examination. The spreadsheet shouldn't necessarily be excluded. Now, Louisiana does follow the Napoleonic Code. It is different than the rest of the United States in many, many ways. So that might be part of what happened down there. Bill, I don't know for sure, but
Nor do I.
It's not consistent with my experience. That's all I can say. Now, here's a question for me. How long into your engineering career did you feel confident about your skills, knowledge, experience to switch over to law? Well, I don't know that I ever felt confident. I think because I didn't feel confident in my skills, knowledge, and experience as an engineer, that's probably why I went over to law. And now I'll be 67 this summer. I've been practicing long enough, I might actually do it. What happened, just briefly, what happened, if you remember from 78 to 82, buildings started collapsing. The CW Post Arena collapsed. Rosemont Arena collapsed under construction. The one in Kansas City Hyatt Walkway collapsed, but the other one in Kansas City had a partial roof collapse. And then the Hartford Coliseum collapsed in Hartford, Connecticut. And I ended up working on that job for a year and a half. And I was going to have to go back to my cubicle and do engineering calculations. And that's when I decided to go to law school. I figured if all these buildings are collapsing, they need somebody who understands this stuff. And I've been able to do that. That was the story, the short story there. The longer story, I will tell you at the next convention where I can see you at the lobby bar of the hotel. Frank says, great presentation. Thank you, Frank. Good to see you. Question, here we go. Stop moving them around. Katie's doing a fabulous job of deleting the questions that have been answered, but then they kept skipping around when I try to read them. Question for me, how was the testing agency responsible for damages in the Duluth project? Because they had missed the fact that they had done the on-site special inspection work, and they had missed that the first pour was T2 rather than T1 mix. Or no, I'm sorry. It was T1 versus T1 revised. There had been a T1 revised mix, and it should have all been T1 revised. And as the special inspector on site, they had missed the T1 versus T1 revised. That's how that happened. Yeah, documentation and emails. That's I think a program on that could be a good idea. Katie, or any other ACI staff, why don't you take that back as a recommendation? Yeah, good point, Bob. No one teaches this in engineering school. You're absolutely right. In fact, I came out of engineering school not really fully understanding what a specification was. I learned that on the job, but no one teaches this hard knock stuff. That's true. What is the role of arbitration in this kind of dispute? Do you use arbitration clauses in concrete contracts? That is a topic for an entire presentation. And I'm going to ask the other panelists here in just a minute after I conclude to get your opinions. But here's my opinion after all these years. Arbitration was supposed to be cheaper, quicker, and private. It's not necessarily cheaper. It's not quicker. My record is the Saginaw Chippewa Tribe Soaring Eagle Casino in Michigan, 103 days in arbitration over 3.5 years. If we'd been in court, it might have been another 8-week jury trial, but it would have been done. And it's not necessarily private because when you get done, a party can go into court to enforce the award and then it becomes public. So I prefer arbitration in smaller cases, quote unquote, whatever that means to you. Case that you can get it done quickly, but not bet the farm. If you're betting the farm in a big nasty case, I actually in general, prefer litigation because I know what the rules are. I know what's admissible. I know what's appealable. And if it goes off the guardrails, I've got another place to go. In Minnesota, an arbitration panel doesn't even have to follow the law on damages. There was a case where a contractor had to repurchase an apartment building from a developer. They took that up to the Minnesota Supreme Court and said, that is not the proper measure of damages. You can't do that. And the Supreme Court said, we give such deference to arbitration that if the panel felt that was the right decision, that was the right remedy, then we're going to enforce that. So arbitration could be a little scary. So the rest of you, what have you seen on arbitration versus litigation? Anybody? Matt, you were nodding your head. Any thoughts? Oh, you're still muted.
Sorry about that. I would have to agree with you. I think that in many cases, arbitration and mediation are not as advantageous as promised. I think you can just be adding additional layers to the dispute and possibly additional cost. And, to your point, there's a certain level of closure, I think, that comes from litigation and from a trial. So it's not always the best option. It can go both ways. I know there are many cases where the arbitrations are helpful and they shorten the process too. So
the scary thing for us in Duluth was we were going to get hometowned because we had a hometown attorney with the taxpayers and the hometown and everything. And then that I was going to be able to explain to a jury how all of this should have been done. And we had a really good jury pool up there and a good jury. And actually, after 8 weeks, we kind of became locals too. We knew everybody in the courtroom as well as anybody else did, as it turned out. So it didn't turn out to be, and interestingly enough, in jury selection, the judge said, is there anybody need to say anything outside the presence of the other jurors? And one guy raised his hand and everybody left. And the judge says, well, what do you need to say? He says, well, I just think that building that aquarium was the stupidest thing the city of Duluth ever could have done. And the other side immediately moved to exclude him. And the judge says, well, in spite of that, can you be impartial in this case? And he says, oh, of course I can be impartial. And he didn't get excluded. They had to use one of their mandatory strikes peremptory strikes to get rid of that juror. But so sometimes assuming that you're going to get hometowned is not a good assumption. So Randy, any thoughts on arbitration?
Yeah, most of the work that we've done or are doing now, almost every contract that whoever the parties are have both a mediation and an arbitration clause. So you have to go to mediation first before you go to arbitration. And most of them, I have not seen too many lately, unless it's a there's some unique circumstances. Very rarely are they mandating that they go to litigation. It's always mediation to arbitration.
Okay. Bill, any thoughts on?
Fortunately, I haven't had any experiences with arbitration or mediation, so I feel fortunate there.
In Minnesota, you can't take a case to trial until you've used ADR, alternative dispute resolution, which in practice has become mediation. We have a really, really developed and good mediation practice, which is a little bit frustrating because I wonder if I'll ever get to try another case. We tend to be, sue the case out, answer, do discovery, take depositions, and mediate. And it's rare. It's rare for a construction case to go to trial because, first of all, the insurance carriers are too afraid to try them, frankly. One other, there's just another thanks. Katie says, do we want some extra questions? Yes, I'm more than open to additional questions. Bill, in the interim, while you're generating any additional questions, I know Bill's presentation was longer than he did, and I forced him to trim it down. Any other stories you'd like to tell from that case?
I got to think about that for a moment. I know you and I have done it together. Well,
that's okay. We can move on. If you think of any, let me know.
Yeah, I sure will. Thank you.
All right. Let me think. Any other? Okay. What is the number one piece of advice to avoid legal issues depending on your role? Well, good question. There isn't really one thing. I'm reminded of, I've used this in Final Argument. You remember the movie City Slickers when Curly, the old cowboy, said, I'm going to tell you that one thing. And then he died. I'm not going to die. And I'm probably not even going to tell you that one thing. Have a good contract. It starts with having a good contract. It starts with reading your contract. It starts with making sure your specs are clear, concise, and coordinated. And then probably the next and most important thing is really good documentation. And I'll let, Matt, Randy, and Bill weigh in based on your experiences. What, if you could find a number one, I couldn't. If you could find a number one thing to avoid litigation or resolve issues, what would it be? Matt?
I think for me, it's what Bill talked about for his talk is the documentation side of it, and trying your best to create a clear and concise trail of documentation of all the steps and making sure that that's communicated.
Yeah, that's a good point.
Yeah, I agree. Jeff, we spent a lot of time. I've spent a lot of time over my career really trying to understand contracts, and most of our E&O insurance carriers now have a very, very good programs about educating engineers about issues, what's insurable, what's not insurable, those sorts of things. So you got to have a good contract, good terms and conditions of, we usually offer our contract, and sometimes they accept it, sometimes they don't. And I also agree that, documentation is key. And then the other, I think the other thing is clear communications. It's so important. A lot of things could be resolved if people communicate, and that's where we find that once you get into loggerheads, it becomes impossible. So we see the need for clear communication. If that's done and the parties, as you alluded to earlier, are willing to talk, you can generally get things settled, but it takes two to tango.
Yeah. Hey, Bill, any thoughts on that?
In avoiding litigation, 2 comments. One, I think you can do everything right. And if you do everything right, that doesn't mean you're not going to end up in court. I've had enough experiences to know that you can be 100% correct and do everything right and still end up in court, and then have it all just fall in your lap. But Jeff, you alluded to this earlier in your presentation. It's so common that all of us take specs off the shelf and we say, oh, this job is just like this job. We're going to go use these specs. And we don't really do a good job in the specs to really tailor those, and we end up with those clauses like yours did with no admixtures, and that just becomes a huge issue to bite you in the butt down the road.
Yep, absolutely. Okay, there are a couple other questions here. Here's a good one. If experts can get to different conclusions about causes and/or repairs, why does that occur? How can it be minimized? Are there resources, procedures that experts should follow? Now, Randy had a quote earlier that I think was probably out of the, maybe it's the NSPE Code of Conduct, I think, or Ethics Code. You know, people like to blame the lawyers for these issues with lawsuits and so on and construction disputes. But I got to tell you that behind every lawyer is an expert who's coming up with an opinion that supports the case. And one of the biggest problems you have, it isn't my problem, one of the biggest problems you have is policing that issue, because you can just about find an expert to back up about any position you want. And that's because the experts are interested in supporting their clients and maybe pushing the envelopes. I mean, you imagine yourself, but that is an issue. And I've seen that as an issue for years and years and years. I don't know how we solve it. I do know that the Minnesota Professional Responsibility Ethics Code has been revised to have a provision similar to what Randy read earlier about, you know, showing the good, the bad, and the ugly as an expert. But I'll let anybody else weigh in, Matt or Randy or Bill, who wants to go first?
My thought on it is there are always three sides to every story: yours, mine, and the truth. And I think that two experts can disagree based on facts. You can have different interpretations. You can weigh different aspects of a case and different technical matters. You can weigh them differently, so you can have a different conclusion. And you know, I've seen two sides of two experts on litigation, you know, very well respected groups on either side present, you know, very accurate and well thought out conclusions that come to different answers, and that, you know, it just happens.
Yeah, I shouldn't. I'm being a little bit negative, I guess. It is perfectly reasonable for different experts to disagree, but I do see times where there are extreme positions taken as an advocate, not necessarily as a neutral expert. Randy, what do you think?
Yeah, I agree. I've definitely seen times where you know, it's a matter of interpretation. No one's interpreting that particular set of data incorrectly, or and you arrive at different conclusions. That happens actually fairly frequently. I know in terms of I have been involved in projects where, and typically when you're retained, you may not be retained as an expert originally. You may be retained just as a consultant, and until you know what your opinions are, would you be named an expert? So I've had been in projects where we go through and develop what we think went wrong, and it isn't to the best interest of the party to engage us as an expert at that point. So we've had to say goodbye.
And
so
the advantage to us lawyers doing that is if you're a consulting expert, we don't have to disclose you later,
right,
as a testifying expert. Yeah.
Right. Yeah.
Bill, any thoughts?
No, well said by Matt and Randy.
All right, another question. Has DOT checked all bridges across the country now based on that bridge failure and others, or should we be worried about driving across steel bridges still? Really good question. I believe Minnesota has gone through checking bridges. I don't know about the entire rest of the country, but I believe that has been undertaken as far as I know.
Well, there's a federal mandate after 1974 incident in the Schoharie, I think that's named River in New York. So they're biennial inspections. Every 2 years there's an inspection. A bit of the problem with that is, you know, new bridges don't need an inspection in 2 years. but the ones that are 60 years old may need an inspection every 6 months, depending on the criticality of it. So there's a bit of a, and that's one of the things the the bridge industry is looking at. There's a mandated fracture if it's a fracture critical bridge where one member or one connection can go, then they have other requirements that are mandated for those fracture critical bridges. But I would suggest that this biennial inspection, it would have been very difficult with a biennial inspection, Jeff, to catch that issue of the buckled plate. They're just not looking at it with that kind of degree of insight.
It's one of those issues when after the fact it jumps out at you and
Right.
it's obvious, but at the time it's not.
Exactly.
Yeah. And it's hard to wrap your head around a bridge that's been standing there for 40 years would have an original design error.
Yeah.
And I've gotten into debates with some engineers about this. They just tell me that can't be true. And I said, read the NTSB report. It's really simple.
Yeah, absolutely. I mean,
A couple other questions here I'd like to get to. Have you had instances where an engineer deviated from CSI standard specs for better or worse and had legal issues down the road? Regardless of whether there's a deviation from CSI standard specs or not, the problems come up when you're not clear, concise, and coordinated. So clear, concise, coordinated are the rules regardless of the source of the specs. Next, how much responsibility lies with the AE versus the contractor for discrepancies between specs and details noted on the drawings that are, for whatever reason, not caught or clarified in an RFI? So anonymous, whoever you are, you're asking good questions. And again, we talk about this kind of stuff at ACI 132, which is responsibility in concrete construction. The engineer's job is to develop a set of specifications and drawing notes that are clear, concise, and coordinated. Now, the contractor's job, according to most of the standard contracts, is if they observe inconsistencies, to ask a question, bring them to the attention. But their job is not to do quality control for the engineer. And there's no way an engineer can rely on the contractor to do quality control on the drawing specs and notes on the drawings. So sometimes the issue might get clouded a little bit by asking, why didn't you issue an RFI? But that's really only a fair question if they actually noticed the discrepancy and didn't raise it. Any other thoughts on that one? We got 3 minutes left.
Jeff,
All right.
I was going to suggest anonymous as an opposing counsel to you on a case.
Yeah, no, I'm curious now to know who anonymous is, because there've been some real good questions coming from anonymous attendee. I don't think anybody from my office is watching, but I don't know. Okay, well, I think, does any of the panelists have any, I moved through some of those quickly. Any of the panelists have any thoughts or questions we didn't get to address, or thoughts?
I wanted to just make a comment, if I could, back to the question about safety of bridges and how often they're being inspected. I think as an overall comment, our infrastructure keeps being, we rate our infrastructure every year. We see report cards of C-, D+. I mean, there are a lot of states that don't have sufficient budget to do the repairs necessary. This is a rampant problem throughout our country and in other countries. And, I think that it is a good thing to talk about, because it gets people thinking, this is a worthy way to spend public dollars to ensure that these structures are safe, even though it might be a long period of time between occurrences of some kind of tragedy. But we need to talk about these occurrences so that we can keep it fresh in our memory and make sure that we take the right steps.
Yep. I think a closing thought for me is, I swear that I learned when I started engineering school in 1972, it was somewhere between 72 and 76 and 7, that the Eisenhower interstate system was designed with a 50-year service life.
Mm-hmm.
We're well past that 50-year service life.
That's right.
Yep.
Unfortunately, it's probably going to mean we're going to have to put up with a higher gas tax or something to fund it, but it's got to be done. It's just like the roof on your house that starts leaking, you got to fix it. All right. Well, with that said, we're 1 minute away from our ending deadline. I want to thank everybody for attending, and I want to thank my fellow panelists for being here today. I think this went well, and I appreciate helping me with it. Thank you, everybody, and have a great rest of your convention. And please attend the president's reception. There's some additional awards handed out there, some additional remarks we make, and if you can share a drink with me. So come Wednesday night to the president's reception, please.
Thank you.
All right.
Thanks,
Bye.
everyone.
Thanks.
Thanks.